A federal judge looked at concealed carry permit delays and basically said, enough. Pause. And now the fight against permit office abuse is getting backup from the U.S. Department of Justice and a coalition of states. Quick question before we go any further. Are you subscribed yet? Because what I'm about to break down could change how you think about permit delays, carry rights, and what local offices can get away with. If you care about your right to protect yourself, hit that subscribe button right now, because most gun owners do not hear about this stuff until it is way too late. Here's what just happened, and this is the part that shocked me. A federal judge had already signaled that long delays in Los Angeles County's concealed carry process likely crossed the line. Then the DOJ stepped in with something we almost never see in this space: a federal civil rights lawsuit filed in support of gun owners. The DOJ says the Sheriff's Department was not just slow. It says the department created a pattern of delay so bad that the right to carry became meaningless in real life. In plain English, the claim is simple. If the government makes you wait so long that you cannot use your right when you need it, that delay can act like a denial. Sourced, or let me break that down for you. Between January 2024 and March 2025, the DOJ says Los Angeles County received 3,182 new concealed carry applications and approved exactly two, not 200, two. The complaint also says applicants waited an average of 281 days just to get moving in the process. The median delay was 372 days. Some people waited as long as 1,030 days, and thousands of applications were still pending. Even worse, some interviews were already being set as far out as November 2026. That is not a normal backlog. That is the kind of delay that can kill a right without ever officially saying no. Source. Now, this is where it gets interesting. California law itself says licensing authorities are supposed to make an initial determination within 90 days. So the DOJ is not just saying, we don't like how long this takes. The DOJ is saying the office blew past even the state's own timeline and then kept doing it in a way that burdened a constitutional right. That matters because courts often look hard at whether the government is following its own rules before they even get to the bigger constitutional question. Source. But here's the crazy part. A lot of people hear this story and think, well, that's California. That doesn't affect me. That is the wrong takeaway. If you live in a permit state, this can affect you directly. And if you live in a constitutional carry state, it can still affect you when you travel, when you apply for reciprocity, or when local officials decide to use paperwork as a weapon. Most people think a rights fight is always about a direct ban, but the truth is, delay can be just as dangerous as denial. Imagine you are a single mom in a rough neighborhood. You apply for a carry permit because your ex has been making threats. You follow every rule. You pay the fees, you submit fingerprints, you do the training. Then the office tells you to wait 9 months, maybe a year, maybe 2. What good is your right in that moment? Here's a hypothetical example to explain this. If your smoke alarm only starts working 6 months after the fire, you never really had protection when it mattered. That is the point these cases are driving at. And don't make this mistake. This does not mean every permit law in America is dead tomorrow. It does not mean you can ignore your local rules. What it does mean is that courts, and now the DOJ, are paying serious attention to whether permit offices are using delay, cost, and endless steps to choke off a right they are supposed to process. That is a huge shift. The Supreme Court's 2022 Bruen decision is the reason this fight got so much bigger. Bruen said the Second Amendment protects the right of ordinary law-abiding people to carry a handgun for self-defense outside the home. The court also said states can still use objective permit systems. Objective just means clear rules, like background checks or training, instead of some official saying, I just don't think you need one. But here's what most people get wrong. An office can pretend to follow an objective system while still making the process impossible in real life. That is exactly why these delay cases matter so much. Source. If you're finding this helpful, imagine what you'll learn in my next video about the 5 words that can protect you when police ask about your gun. Subscribe so you don't miss it. I spend hours digging through these cases, so you don't have to. Now let's talk about why this could spread far beyond one county. The DOJ did not just send a warning letter. It opened what it called a first-of-its-kind Second Amendment pattern or practice investigation, then filed what it described as its first affirmative lawsuit in support of gun owners. That means the federal government is treating this like a civil rights problem, not just a local paperwork mess. The message is simple. If a department develops a pattern of blocking ordinary people from exercising a constitutional right, the DOJ may now step in the same way it has stepped in on other civil rights issues. Source. That should get your attention because it changes the pressure on local permit offices. Before, a person usually had to sue on their own, spend money, wait forever, and hope a judge cared. Now there is at least some sign that the federal government may also step in when the abuse gets obvious enough. And once one department gets sued, every other department in the country has to ask itself a hard question. Are we following the law, or are we slow-walking people into surrender? Here's the part nobody's talking about enough. Delay is only one form of permit office abuse. The same basic playbook can show up through crushing fees, repeated document demands, limited appointment, windows, or interview calendars so packed that your application becomes stale before anyone even looks at it. One office might say, "We never deny people." Sounds great, right? But if they also never process people, the result can be almost the same. Have you ever wondered why local officials sometimes prefer delay over denial? Because a denial is clean. A denial gives you something to appeal. A denial creates a paper trail. Delay is murkier. Delay wears people down. Delay makes some applicants quit. Delay lets an office say, "We're working on it," while your rights sit in a pile on somebody's desk. That is why this issue matters so much. Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. Let me give you another real-world scenario. Imagine you finally get your permit, but only after 15 months. During that time, you kept driving home from work after dark, you kept making cash deposits for your small business, you kept hoping nothing bad happened. If the whole point of the right is self-defense, then the timing is not some side issue. The timing is the issue. A delayed right during a dangerous season of your life can be no right at all. And there is something even bigger under the surface. These cases are forcing courts to decide whether the Second Amendment will be treated like a real constitutional right or a second-class one. Think about other rights for a second. Imagine needing government approval to speak at a protest, but the office takes 2 years to answer. Imagine needing a permit to attend church, and the office approves only 2 out of nearly 4,000 applicants. Everyone would instantly see the problem. That contrast is exactly why this fight has so much energy behind it. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the gun owners who want straight, timely legal updates without the nonsense. Hit subscribe and stay ahead of the next change before it lands in your state. Now, this is where the story gets even more important. The backing is not just coming from the DOJ and one county delay lawsuit. In a separate Supreme Court fight out of Hawaii, the DOJ and 26 states backed a challenge to a post-Bruen carry restriction that critics say turns ordinary carry into a trap. Hawaii's rule made it a crime for licensed people to carry on private property open to the public unless the owner gave clear permission. Think about what that means in normal life. Grocery stores, gas stations, restaurants, parking lots, the places you go every day. The DOJ said that kind of rule can function like a near-total ban on public carry. Source. Why does that matter for permit office abuse? Because it shows the larger battle. After Bruen, some governments could not openly shut down carry. So critics say they started looking for indirect ways to do it instead. One way is delay. Another way is turning almost every useful place into a no-carry zone. Another way is flipping normal rules so that a permit exists on paper, but becomes almost useless in real life. Different tools, same result. The 26-state brief in that Hawaii case made the point in very plain terms. Those states said Hawaii flipped the default rule. Instead of carry being allowed unless a property owner says no, carry became banned unless the owner says yes. And because most businesses never post a yes sign, the states argued the rule worked like a de facto carry ban for ordinary permit holders. In other words, the permit stays in your wallet, but the right shrinks the second you step onto the property where daily life actually happens. Source. But wait, there's something even more important. The DOJ's Hawaii brief used language that should make every viewer stop and think. The federal government argued that states cannot evade Bruen by indirect means. That is the key phrase. Indirect means. Not always a direct ban, not always a law saying no. Sometimes it is a maze, a delay, a default rule, or a process that looks legal until you live under it. Source. So what should you take from all this? First, if your permit office is dragging its feet, do not assume that is normal or lawful. Second, keep records. Save emails. Save appointment notices. Save payment receipts. Save every date. If a court ever looks at your case, the timeline may matter more than your opinion of what felt unfair. Third, do not rely on headlines alone. Some headlines will make it sound like all permit systems are about to vanish. That is not what is happening here. The real issue is whether governments can make a right useless through delay and indirect restrictions. And let me say this clearly. Even if you support permits in some form, you should still care about this case trend. Why? Because any system with government power needs limits. If an office can bury you in months or years of waiting, then the real rule is not the written law. The real rule is whatever the office feels like doing that week. That should bother you whether you're pro-permit, anti-permit, or somewhere in the middle. Laws change fast, really fast. Subscribe now because the next video explains exactly what questions to ask your local permit office before your application gets stuck in limbo. If you wait until a deadline or a hearing date hits, you may already be behind. Here's the bottom line. The big message from these fights is not that every permit law is gone. It is that courts, the DOJ, and multiple states are now openly pushing back against the idea that permit offices can stall, squeeze, and sidestep your rights through bureaucracy. A right delayed can become a right denied, and more judges are being asked to say that out loud. So if this matters to you, subscribe right now and send this video to one friend who still thinks permit delays are just paperwork. They're not. They can decide whether your rights exist when you actually need them. And one more simple legal disclaimer before I go. Always check the laws in your state, follow current rules, and talk to a qualified attorney if you need advice about your own case.